Hello there, good evening, and welcome to Political Scope. I'm your host, Edward Lane. Law and order is a critical element in the development of any country. I have with me in studio today to review the legal sector over the past 12 months is the Honorable Anil Nandalal, Minister of Legal Affairs and Attorney General. Minister, welcome to the program.
Thank you very much.
Looking back at the past 12 months, a year mixed with challenges and successes, your general overview of 2014.
As you rightly said in your introductory remarks, the year 2014 has been indeed a challenging one. The Ministry of Legal Affairs was confronted with several very trying situations. For example, we had to confront the issue of the non-passage of the AML-CFT bill, and that resulted in Guyana being put under um, very pronounced scrutiny and a very intense regime of evaluation and monitoring. And since I am the subject minister, the Legal Affairs Ministry, along with the Financial Intelligence Unit, um, the Legal Affairs Ministry in particular, has been the agency leading that initiative and endeavor to comply with those very stringent evaluation processes to which we were subject as a country. So that's one challenge. Of course, the Ministry of Legal Affairs bears the responsibility of giving legal advice. Well, the Attorney General and the Ministry of Legal Affairs bear the responsibility of giving legal advice to the government of Guyana. As you know, the government of Guyana is a multifaceted, amorphous amalgam of various agencies, statutory bodies, ministries, and many people don't know how vast the type of advice which has to be disseminated on a regular basis is, because you're dealing with a wide spectrum of agency, but that is done in-house, so the public is not really aware, but it's a very, very onerous task. And so that has to be undertaken. Then you have the litigation aspect of the ministry's work, and that is to defend all the agencies that fall under the rubric of the government of Guyana in every litigation, and to prosecute cases on their behalf. Of course, to give legal advice and represent the Guyana Police Force. That alone is a big challenge. And more significantly, to advise the cabinet and the government of Guyana, central government, that is, the president, the cabinet, more particularly on matters that are taking place at the political level and at the parliament. Invariably, the issues which arise in the parliamentary mix-up are legal issues, and they require regular advice and discussions and so on. So, and they are complex and complicated on many occasions. We are dealing with issues that have never been dealt with before in Guyana and sometimes elsewhere. So it's a very novel exercise one has to engage in coming up with interpretations of constitutional provisions that have never been interpreted by any court, dealing with situations unfolding in the National Assembly that never occurred before in our history. So, in total, it has been a very challenging year.
You touched on the MLCFT, the Anti-Money Laundering and Countering the Financing of Terrorism Amendment Bill, which that's an issue that was brought forward from 2013. Um,
2012, actually.
well, 2012, 2013, it's an issue that's been ongoing for quite some time. Guyana would have been, like you rightly mentioned, subjected to a number of reviews. Uh, Walk us through a little in terms of the activities during the course of the year with regards to getting this particular piece of legislation passed.
Well, first of all, drafting the legislation has been, drafting the bill rather, has been a challenge by itself. When the recommendations come to you, they come to you in very complex and technical language, and then you have to reduce that into, first of all, you have to understand what is it that they are seeking to promulgate as a law. Then, when you understand that, you have to subject that to scrutiny against the Constitution to see whether it is going to be unconstitutional if you are to reduce it in the form that they have given it to you. And then you have to also examine other pieces of legislation to see whether they are going to conflict with those pieces of legislation, because the recommendations come to you, they come to you in a very vague language and in that technical way of expression. So you have to subject it to all these analyses, and then at various stage during that process, you would have to send it back to, let us say, CFATF for them to examine what you have done to ensure that you actually satisfy the requirements or the recommendations that they want at that point in time to be implemented. So it's quite a complicated and sometimes tedious task to get that draft done. Then when you get that draft done, you have to take it to the parliament, where you are met with another ordeal of getting it passed, not because of any complexity in the legislation, in the bill, but because of political reasons, because no one has really ever objected on merit to anything in these bills. The opposition who have been rejecting all the bills that we have put forward under the rubric of the AML-CFT requirements have really rejected them for no reason, or for few reasons related to the bill themselves, but on other political considerations. So you have that. As a result of that, we are where we are now, in a non-compliant state, and and we are the only country in the Western hemisphere that is so circumstanced. And when a country finds itself in this state of delinquency, then another regime of scrutiny and evaluation step in. And you are required even more onerously now to satisfy more requirements. And that is the stage where we are at, where a work plan has been given to us, which contain two components, a non-legislative component and a legislative component. And we have been given two different sets of time frames to comply with each component. And you are monitored with unusual frequency in terms of your rate of implementation. of that which is contained in the agreed plan. For example, early January, we are required to do a teleconferencing with the review group of the Americas to give them an update on what we have done since we were last reviewed by them. And then February, we have to go to Paris for another round of assessment. And then in between all of that, you have the meetings that you have to go to at the level of the Caribbean Financial Action Task Force and now the Financial Action Task Force. And because of the non-compliant state in which we unfortunately find ourselves in as a country, at every one of those meetings, you are required to present a case to prevent further sanctions. And that is also a challenge by itself because you now have to address a large audience, most of whom are critical of your non-compliant state because the whole basis upon which this evaluation criteria is arrived at, it is based upon peer review. It's a mutual evaluation review, basically. So you are being reviewed by everybody at that forum at which you are presenting. So you obviously have to be well prepared and be au fait with all the facts and circumstances about and concerning your case and have explanations in terms of when you would be able to extricate yourself from, as a country, from the state of delinquency in which you find yourself. So that by itself is quite a challenging task on the whole, every facet of it that is. As a result of those responsibilities, we have established within the Ministry of Legal Affairs an AML-CFT unit. And this is a small unit that works very closely with, under my supervision, and we work very closely with the Financial Intelligence Unit to satisfy these requirements and to discharge the various responsibilities which devolve upon us as a country.
But you would have said, the government would have said before that they were able to address the non-legislative recommendations. However, it's public knowledge that we are at a standstill with regards to the legislative recommendations. How has that impacted on Guyana as a country over the past year or so?
Well, fortunately, we have been able to prevent Guyana from being blacklisted. And that is a significant accomplishment, having regard to the state of delinquency in which we are in. The Guyana is still at the level of CFATF in the Caribbean and Latin American region, a country that all the other countries have been invited to take appropriate sanctions against, so that to protect themselves from the risks which Guyana as a country poses. And so at a certain level in terms of trade, there are hindrances and there are problems that are encountered on a daily basis. But we have been able to ameliorate the situation largely by creating an internal menu of measures within the financial infrastructure of Guyana through administrative policies, through ministerial directions under my hand, through regulations, and through guidelines, ministerial guidelines, that have sought to impose on the financial agencies that are caught within the AML-CFT regime and to get them to comply with a host of the very recommendations which are captured in the bill, but that bill has not been passed. We have been able to extract them and put them into these various um, recommendations, ministerial guidelines, and ministerial orders, and promulgate them to be complied with by the various agencies. And that, I believe, has that that initiative, I believe, has substantially um, helped in our banks, for example, being able to show to their other um, their agency, their equal overseas, that look, we may not have it as a law, but we have these requirements. We are complying with these requirements. And central bank, as a supervisory agency, supervises these banks and these other and every, remember, we have appointed supervisory authorities in almost every sector which is embraced by the AML-CFT regime, be it the insurance companies, the banks, the pawnbrokery, the other licensing agencies, and each of them fall under a particular supervisory authority. And that those regulations, ministerial guidelines, etc., are being enforced through that hierarchical structure of mechanism. So there is, though not law, there is a set of rules and regulatory framework which govern the way these financial institutions operate. And that has been able, I believe, that has been able to prevent any really harsh regime of sanctions being imposed on the financial sector of our country when they interact internationally.
The MLCFT is an amendment to an existing law.
That's correct.
Let us talk a little more about other laws that were amended, revised over the past 12 months.
Well, significantly, we attempted, for example, to amend the Customs Act to remove from it a discriminatory element which would have made us compliant with our treaty obligations under the Treaty of Chaguaramas, and that is to remove barriers that are discriminatory from goods manufactured within the region that are traded interregionally. And I speak of what is loosely described as the environmental levy. We we were sued by Rhodesa International, the country Guyana, because we are in violation of the treaty. And you know, the CCJ has an original jurisdiction to adjudicate all allegations of violations of the Treaty of Jaguaramas and indeed any other treaties emanating out of CARICOM. Invoking that original jurisdiction, a company in Suriname took us to the court, and the court allowed us a very long period of time to get this bill passed through the parliament, which would have removed this offensive aspect of the custom laws. It was put to the parliament. The situation was explained in great details by myself and several other members of the government. But the opposition rejected it, and as a result, judgment was granted against Guyana, and we are now to pay 6 million US or thereabouts, and we have been ordered to cease collecting the taxes. So that is one. But we have been able to pass a number of legislation Um, some, for example, the one that conferred, f- some that conferred great, uh, um, what should I say? That some that were intended to directly address certain lacuna in our law, which exist for a long time. And I specifically recall the one dealing with bringing the spouse in a common law union where the other partner has died, to bring that spouse to equal footing if that spouse was unmarried, to bring her to equal footing as if she was married. We had to amend the law dealing with intestacy, because under the rules of intestacy, only a married wife was recognized. Um, and we have legalized common law union some years ago, but this aspect of the law was never changed. So a common law wife, though would have satisfied the requirements of a legal wife for the purpose of qualifying for matrimonial property if the husband is alive, if that husband died, she does not enjoy such qualifications because the intestacy law did not protect her, did not recognize her. So that, I believe, was a substantial piece of amendment that would impact positively on the life of the unmarried woman in a common law union. So that I believe was a substantial achievement. Um, Another important, and there were several other important pieces of legislation which we passed in 2014. I can't remember them now, but we passed several. Oh, we for example, we allowed a criminal an appeal to be filed against a case where it arose out of a criminal cause. It may be a little very complicated to explain now, but that was there's no appeal used to be available under the previous law. We changed that, and now an appeal is available under that law. And there are many, many other different pieces of legislation.
Significantly, one of the significant pieces had to do with firearms. The firearm amendment, I think, was done earlier this year with regards to components of firearm.
Yes, I believe that is now, that was passed.
Yes.
Yes, it was rejected for us by the opposition, and then I think I tabled it, and then it was passed by the opposition eventually. That is another important and vital piece of legislation which we passed.
Talk a little about what are some of the plans in terms of continuing the review of the laws of land.
Well, we have, for example, we have the education bill, which has already been tabled. We have a comprehensive hire purchase bill, which is to be tabled, and that will correct a lot of the injustices which are taking place now, because we have no statute law governing hire purchase. Our hire purchase law is the old English common law position, whereas the title resides with the owner, and though you think that you purchased the vehicle, and you have an agreement of sale basically that says that, when you have a hire purchase agreement, you are essentially renting that vehicle. Title remains with the owner, and you may pay a substantial portion of the purchase price, and if there is default in one singular installment, the owner repossesses the vehicle and forfeit all the money that you have paid, and you have lost the vehicle and you have lost all your money. We have a bill that is going to correct that and many other draconian aspects of the common law of hire purchase. Um, that one is in the pipeline. Significantly, we have completed the domestic violence regulations. You know, we are still a society confronting in a serious way a domestic violence problem. We have a good piece of legislation which we passed in 1996, but though it has brought substantial awareness to domestic violence and it has made a tremendous change, and we can analyze that in another discussion, we still have the problem confronting us, and there is always need to update the legislation. We have completed a comprehensive network of rules that came out of discussions that would have been held over a long period of time by ministers of human services, by consultants. They would have looked at the act itself. They would have spoken with practicing lawyers, and those discussions together would have produced um, an amalgam of recommendations. And those recommendations would have specifically addressed deficiencies that would have been identified over the last 20 years or so since the act has been in force, and seek to correct them. So we have that ready, and that will be promulgated very, very shortly. Uh, uh, um, the Minister of Human Service will determine how that will be done. Then we have completed a few amendments, but significant amendments to the very Domestic Violence Act itself, because we feel that the definition, first of all, there is not really a definition of domestic violence in the Act. And this amendment, which we are proposing, embraces a very wide-ranging definition of what domestic violence is. And we have looked at the international organizations for guidance, because they have many documents that they have prepared on this issue, and they have come up with a definition. So we have looked at several definitions and have culled what we consider to be the most comprehensive and all-embracing of the definitions, and that the Act will be amended to incorporate that shortly. Um, we have whistleblowing legislation that I consider to be very important. We have an anti-terrorism bill that is in the pipeline. We have an e-governance bill. We have a whole host of bills that are to be promulgated.
But I want to bring you back to the amendments to the domestic violence law. And one of the recommendations you hear often from persons, organizations that are fighting against domestic violence and so forth, is for there to be more stringent penalties for those who commit the act. Is that part of the
That is part of the amendments which are being proposed by the Act, which are being proposed to the Act. Um, so yes, penalty is addressed. The regulations make the Act easier, more user-friendly, so to speak, because there are hurdles that an applicant under the Act have difficulties in overcoming. Practical difficulties, service of documents, and that type of thing. And we need also, and those are addressed in the regulations. And we also need to empower the magistrate to make a greater variety of orders, as well as to have a wider latitude of sanctions which are imposable in fit and proper cases once those cases are established by way of evidence before a court. So, yes, the issue of penalties are addressed. Another important thing that I want to speak to, because it has generated some public discussion, is the laws of Guyana. You know, after 40 years, we completed the revision of the laws of Guyana. Expectedly, there were mistakes, there were defects, there were omissions. We we are in the and that is expected. That was anticipated. We have begun. We began very early a process of identifying what these omissions are and accumulating them, what these errors are, what these deficiencies are. We have established a law revision unit within the ministry, and that unit is responsible for that. With the help of the CARICOM and Commonwealth Secretariats, we have been able to solicit the service of a very distinguished law revisionist, if I may describe him as that, because he has worked throughout the Caribbean and indeed throughout the Commonwealth in many parts of Africa, doing the same thing or engaging in similar exercises. He is now heading the initiative now ongoing at the ministry, and we are hoping that we have sent out letters and so on asking for persons who may interact with the laws and identify deficiencies of their own to forward them to the unit so that we can begin the exercise, or rather we can accelerate the exercise and hopefully conclude it. So that's another important initiative which we have commenced in the year 2014.
I want us to come back a little later to Parliament itself and some of the issues in Parliament. Um, we will deal with that just now, but I want us to talk a little about what has been happening at the Deeds Registry. Quite a lot of work, I understand, has been ongoing there. Tell us a little in terms of the activities. I
The,
know.
the deeds registry over the last year has undergone very transformational changes at the level of its structure and consequently its administration. There is a completely new infrastructure, administrative infrastructure in place, established by an act of parliament. There is for the first time, for the first time, there is a body corporate, a statutory body corporate, that is now the Deeds and Commercial Registry Authority, and it is run by a board. The board is very broad based in its composition, and an Act of Parliament describes who are on the board. It's made up of a chairman nominated by myself, or appointed by myself, I think. And then there are various bodies represented on the board: the Bar Association, the Georgetown Bar Association, the Berbice Bar Association. You have a representative from the commercial sector. You have a representative from the housing sector. You have a representative from the finance ministry. Um, so it's a very broad-based board, and of course the registrar sits on the board as well. Um, we were very successful in moving the staff from being from their status hitherto as public servants and converting them into employees of this statutory authority. Of course, that was a very tedious exercise because you had to undergo a process of calculating, first of all, identifying who had pensionable service, calculating their pensions, then deal with those who don't have pensionable service, but who would have been entitled to a severance pay under the Termination of Employment and Severance Pay Act. In the process, you would have had to negotiate with the union and meet with the staff on a regular basis. So that was a very tedious and time-consuming process. But we fortunately were able to move all the staff almost over to this new body with, I would say, remarkable ease. And 'cause normally there are industrial disputes that would arise from these type of arrangements. But fortunately, that didn't happen in this case, and we were able to transition everyone successfully. Also, of course, there is a dichotomy now. The registry is divided basically in two. On the one hand, you have the deeds registry that performs purely core deeds functions, as really was the contemplation originally. And then you have the commercial registry that deals with commercial documents like um, the mortgages and so on. Debentures and company and business names and trademarks and patents and so on. As you know, we have acquired the old New Building Society building, and we have already acquired the new furnishings, we have already acquired new computer systems, and there is work going on now at the building to prepare the building for the deeds registry, the commercial registry, to move into the building, because we are moving part of the operations from the deeds registry where it is now over to that
New building.
new building society. That is ongoing as I speak in terms of the renovation and repair works which are taking place in the building to ready it to accommodate the new complement of occupants. So that is going on now. So and from all reports, I believe that the changes have been remarkable. We amended the law to facilitate the easy renewal of business names, business registrations. Normally, you would have to line up at the beginning of the year at a particular date to have all the business registrations renewed at the same time. We now have a system that allows for the renewal of those documents at an anniversary date. So it's scattered throughout the year.
This is similar to what happens with the road service licenses for vehicles. So
Yes,
something similar in
something
nature.
like that. So I want to say, based on the reports that I have received, and if anyone, I always encourage persons who encounter difficulty with interactions at these agencies to make it known to the responsible minister. In this case, it's me. If there are any more problems that we can work towards rectifying at the deeds registry, I'm prepared to hear anyone. But I'm not saying that it is perfect. I mean, there's a lot more work to be done. There's a lot more work that we are doing. But I believe that the changes which have taken place, have resulted in an improvement in the efficiency that the Guyanese public is receiving from those agencies.
With regards to records, because this is a significant one, I know a lot of physical records existing. Is there a move to convert?
Yes, there is a consultant who has been retained and who is undertaking a type of assessment or feasibility on how to continue a process which we have started of reducing these records into microfilms and another format from physical documents to store them electronically, and that process has begun. But technology changes. What was available 10 years ago is now outdated now. So we don't want to only continue the process, but we want to improve it as we go along, and as the technology becomes more advanced, we will change the modus operandi to accommodate that which is technologically available. But the initiative will continue. We have perhaps 100 years of documents to that are in the form of paper
To digitize.
to reduce them into some form other than paper. Um, uh, how, how how we are doing it and what form uh, they will take, I'm not sure because as I said, we started digitization at one stage. I don't know whether we will continue that way, right? So there are all these things that are taking place.
I want you to touch on one issues with regards, and this has to do with lands. We've seen during the course of this year at least um, one case made public where a property was sold um, with regards to having a agreement of sale, and that property had a mortgage on it. We know about the issue with regards to the May School, for example. What has your ministry done so far to address that issue at the level of the deeds registry?
I'm glad that you remind me of that because that is one of the most fundamental pieces of legislation which we have passed recently. The legislation that I speak of is the specific law is the amendment which we did to the Deeds Registry Act, where we have made an agreement of sale registrable at the Deeds Registry. And we have made it um, basically to be an encumbrance against the land. Previously, the transport vests in the owner full and absolute title, subject only to certain exceptions, like like a mortgage, rates and taxes, etc. We have now attached to that line an agreement of sale. So an agreement of sale is essentially an encumbrance on the land. So if you have an agreement of sale, the owner can deal with the land as he or she feels fit, sees fit. They are now subject in their dealings to your agreement of sale. What we found happening is that a man would buy a land and pay a deposit, and the owner sells it to another person, collects another deposit, sells it to another person, collects another deposit, and then perhaps then mortgage at the bank, and everyone loses. Their only option is to read when it is advertised in the official gazette, and many people don't read the official gazette, and we have put that online as well, and that's another significant achievement. And they don't know when and how to oppose in any event. So the property passes to a third party, or a mortgage is passed on the property, and all these persons who would have paid deposits in relation to that same property are all defrauded. They all lose their deposit. Now, the agreement of sale is required to be registered at the deeds registry. And anyone who wants now to do an agreement of sale in relation to a property, it would be prudent if they go and check first, because every transport is at the deeds registry. So every property that is owned by transport, a record of it is at the deeds registry. And when you are required, out of prudence, to go there to check first whether this property located at X address has any agreement of sale recorded against it,
So,
or any mortgage for that matter.
how do you advise people? Okay, you said to go and check. Let's say I am buying a property from someone. I'm paying 50% of the cost. We
The
finish
purchase
an
price.
agreement. Yes, we do up an agreement of sale. What do I do with that? Do I go to the deeds registry, get it registered?
First of all, you should be advised by a lawyer. You shouldn't do the transaction by yourself. That's the first thing. The lawyer should know that he or she before he or she advises you to sign the agreement and pay any money, should go and do a check on the property to see that the property is free from encumbrance. If the seller is telling you that the property is free from encumbrance, then your lawyer has a responsibility to go to the registry and do a search on the property to see that it is not mortgaged, that it was never, that there is no existing agreement registered in relation to the property, and so on. So that is what you have to do, so that you would not buy a property and someone else has paid down on that very property.
I want us to examine now the National Assembly. We have just a few minutes more remaining. One of your colleagues on one of these very programs would have described the 10th Parliament so far, and more specifically, the past 12 months of Parliament as a circus. What is your assessment of how the National Assembly would have operated over the past 12 months, bearing in mind we had issues of no confidence motion, cutting of budgets, and a whole host of issues with regards to the actual functioning of the Assembly?
The National Assembly has lost its way. The National Assembly has become a political instrument by those who control it, an instrument that is used to advance political agendas and to pursue uh, goals and objectives that are unrelated to the welfare of the people of this country. And I would go as far as saying to pursue agendas even though they will injure the welfare of the people of this country and the welfare of our country as a whole. And I can give you as example the national cutting of the national budget, reducing the ability of the government to spend money to improve the lives of the people of this country. A National Assembly must never be engaged in an act or an exercise that will have the direct or indirect impact of injuring the people's welfare. Cutting a national budget can only do that because you are making the government unable to deliver social goods and services to the people of the country. Use the National Assembly, use your influence and power in the National Assembly to get the government to do more, not less. That's the first thing. The National Assembly has been used as an instrument to chop down national projects, projects that are designed to advance our economy, to improve the lives of our people. I speak about the Amila Falls hydropower project. Its importance, it's undisputed. Its benefits are hardly debatable. The impact it will have on our economy and on the lives of our people are axiomatic. Yet you have an opposition that chops down that project. Why? Because if a government is able to deliver that type of project to its people, the economy will be boosted, the people's lives would undergo transformational change, the country will undergo a transformational change, and there is a likelihood that that government may never lose power. And that is the philosophy and reason which inspires the opposition inspire the opposition in chopping that project down. The airport project, the specialty hospital, all the Amerindian developmental projects. Why would you want to chop those things down? Why would you want to expose your country to international sanctions by refusing to pass an AML-CFT bill when the entire world has passed the same bill, exposing your economy to embargoes, exposing your people to hardships. That is not what parliament was intended to be. That is not the role that parliament is expected to play. When the framers of the constitution and our forefathers and the struggle to create this place called parliament and to empower this parliament to to do the things that parliaments are supposed to do, it was not in their wildest contemplation and imagination expected that all those powers will be used so viciously, not to advance the welfare of the people, but to repress and suppress the welfare of the people and the life and livelihood of the people of our country, who they supposed to be representing.
You talked about the budget, cuts to the budget, 3 years in succession. It happened in 2012. You had to go to court. You were able to secure a ruling, a temporary ruling in 2013. The same thing happened, forced to go back to the courts to get a final ruling. Again in 2014, the budget was cut. The finance minister using the previous rulings, because the budgets over the years, the process, the procedure remains the same essentially. So whatever ruling was in 2012, 2013, one would believe it's applicable in 2014 and in the future. Um, but as a result of a restoration of those monies, we reached a stage where a no confidence motion was tabled more or less in the House against the government. Walk us through that essentially led to, of course, the prorogation of the 10th Parliament. Walk us through what led essentially to that kind of thinking, maybe with the opposition, having seen the results over the previous years with the court case.
Well, as I said, that is another outstanding example of Parliament, or rather the National Assembly, being used as an instrument, a political weapon against the government as well as the people of Guyana. We restored the monies that they did not grant approval for, as we have done in 2012, as we did in 2013. In 2012 and 2013, they agreed for the restoration. And I have the resolutions from the Parliament saying that Parliament passed these resolutions when we laid statement of excesses, and they were approved. That's what the resolutions of the Parliament say in relation to financial papers laid by Dr. Ashni Singh. The identical thing is done in 2014. And because we did that, you know, Mr. Ramjatan, I think, went to the police. That's a whole other story by itself. The police did not charge as usual. There's nothing to charge for. The Constitution authorizes the Minister of Finance to act in that manner. So they became frustrated, so they decided to, well, we will bring down the entire government. Why? Because we have restored the monies to the budget that they have not approved. Because we have given the school children their vouchers for the we care vouchers, because we restore the student loans at the university, because we restore the Amerindian Developmental Fund, because we restore the monies for the airport, because we restore all the hinterland airports, airstrips that they cut out, and all the hinterland roads that we wanted to fix, and they cut all out of the budget. We put back the money there. We put back the subsidy to Gaisuku. We put back the subsidy to GPL, because we are saying that the consumers of Guyana are paying enough for electricity, and we need to help them. And we put money in the budget to help them, and the opposition cut it out. And we put it back. And because we have done these things, they move a no confidence motion to overthrow the government. There is nowhere on planet Earth that a responsible National Assembly behaves in that way. That is not the role of a National Assembly. If the government was doing something against the people of this country, then you could have understood. But because the government wants to do more, the opposition wants us to do less. And that is the battle in the parliament. The battle in the parliament over the last 3 years is a battle by the opposition to force the government to do less for the people. And the government has been fighting to do more. And that is the tug of war that has been going on. And because we are prepared to do more for the people of Guyana, they decided that they'll bring down the government. And the president was advised that your government should not be brought down, that there are constitutional mechanisms that protects your government from a no confidence motion and that you should use it. And we have used it, and the president has prorogued the parliament. And that is where we are now.
Looking ahead, Minister, we have to wrap this up. We maybe have about a minute or so more. Looking ahead, we are about to start another year. Parliament is prorogued. We're waiting on the way forward from the president. Your vision for the year ahead.
Well, firstly, we still have a case that they have now filed. Not only were they prepared to bring down the government because the government wants to spend more for the people of this country, they have taken the government to court. They have taken Dr. Ashley Singh and myself to court because we have restored the money. And they are seeking an order from the court to prevent the government from spending the money. But, as usual, the action is defective. They are seeking to prevent something that has already happened. The monies have already been restored and largely spent. And the monies only relate to the year 2014. By the time the action is heard, we will be in the year 2015. And different legal considerations, different constitutional arrangements govern the spending of money in a new fiscal year. So the action that they have filed is almost stillborn. It's not going to yield that which they expected to yield. So it's an action in futility, in my view. But for the year 2015, the most significant political event, and the most significant event in our country, rather, would be national elections. So I suppose that we have to prepare ourselves and prepare our people and prepare GCOM to run a peaceful elections. And I want to reiterate that I hope that will be run, this election will be done, will be conducted peacefully. People will be allowed to exercise their franchise freely, that people will be allowed to make their own judgment in terms of who to vote for, that race and ethnicity will not be imposed on our people and not be used as political strategies, because it is being used by certain political parties already, and so that the people can make their informed decision based upon merit, based upon track record. Look at the last 3 years, look at what the government has been doing, look at what the government has done before for the people of this country. Look at the little power which the opposition, joint opposition, have been given from 2011 to now. Look at what they have used the power for. Have they used the power to get anything from the government? Other than their little personal battles that they want? They want to sit in here, they want to make this decision, they want, that doesn't help the man in Buxton, it doesn't help the man in Port Morant, it doesn't help the man in Urupuduni. That just helps someone's ego, that they get, they get a little more power. So that is what the people of this country will have to look for. Look at who is really serious about the development of our country.
Minister, I want to thank you very much for joining us today, and of course, we want to thank you very much for joining us at home. You were looking at the review of the justice sector, of the legal sector rather, over the past 12 months. Thank you very much, Minister.
Thank you.